go. Good afternoon, everyone, and welcome to our June SARA speaker series. My name is May Remenda, and I am a knowledge broker at the Center for Education and Research on Aging and Health, or SARA for short. June is Seniors Month in Ontario, and it's a time to recognize the contributions of older adults in our communities, but also to raise awareness about the challenges that they may face. So in that spirit, today's session is going to focus on a critical and often under-discussed issue, which is elder abuse and the law. We're thrilled to have Dr. Joan Braun with us today to speak on this subject. But before I dive deeper into the introduction, I just have a few more things to mention. Lakehead University respectfully acknowledges its campuses are located on the traditional lands of the Indigenous people. Lakehead Thunder Bay is located on the traditional lands of the Fort William First Nation, signatory to the Robinson Superior Treaty of 1850. Lakehead acknowledges the history that many nations hold in the areas around our campuses and is committed to a relationship with First Nation, Métis, Inuit, based on the principles of mutual trust, respect, reciprocity, and collaboration in the spirit of reconciliation. As a center, we are committed to working towards reconciliation and decolonizing our work, and have committed as a staff to educating ourselves in these areas, both personally and professionally. A few housekeeping points to keep in mind. Please keep your microphones muted during this session. Dr. Braun will be leaving some time near the end of the session for some Q&A, and at that point, we would be very happy to hear your voice. But if you aren't comfortable talking on screen and have a burning question, please just put it in the chat, and I will bring it forward for you. Just a note that this session is being recorded, and I will make it available on our YouTube channel at a later date. Also, Dr. Braun has agreed to share her slides with everyone that's on the session today, so watch for that email. A very short evaluation survey will pop up on your screen after the session ends, and we would really appreciate it if you could fill it out. Your input helps us plan our future sessions. And now on to the introduction. Joan Braun is a professor at the Bora Laskin Faculty of Law in Thunder Bay, Ontario, where she teaches criminal law, administrative law, elder law, and alternate dispute resolution. Her research examines the real-world impact of laws and policies on the older adult population. It focuses on 3 areas of interest: legal and policy responses to elder abuse, human rights perspectives on mental incapacity, and accommodation of cognitive disabilities and alternate dispute resolution processes. Currently, she is a co-investigator on a SSHRC-funded project examining mental capacity and capacity assessment in the context of abuse, neglect, and self-neglect. Welcome, Dr. Joan Braun. And with that, I'm going to stop my sharing and pass it off to you.
Okay, just give me 1 second to get my slides up here. I presume now we can all see the slides. If not, just let me know.
So, thank you.
Yep, we can see them good. So welcome, everybody. I just might add a comment about myself before I start. My bio mentions my professional background, but doesn't really mention how I became interested in these issues. So I think that merits a brief mention. So I was in the social work field essentially before going into the legal field and eventually becoming an academic. And shortly after getting my law degree, I was asked to set up a legal aid clinic for older adults in British Columbia. And many of our clients had experienced elder abuse, or they had family members who were concerned about potential abuse. And I became really passionately interested in the issues, which led to my studies in my area of current research. So that's just a little bit about me. Today, I'm going to give a bit of an overview very briefly on elder abuse, and also provide some background by discussing applicable federal and provincial laws. And then I'm going to focus on current policy questions and some of the critiques of the criminal justice system in responding to elder abuse, and conclude with a few of my own comments about implications and possible recommendations for improving the response to abuse. So there we go. I just will start. I'm sure that many people on in this webinar come from different backgrounds. So some of you may have a legal background, some of you may have a strong background in working with older adults. So you may know some of the background material, but I want to just put it out there first by way of context. So, speaking just very briefly about elder abuse, essentially, there have been different prevalence studies about how common abuse happens. There are different definitions of abuse, but most experts agree that there are essentially four different types of abuse. Some would add additional things like spiritual abuse and so on, but the four primary ones are psychological, physical, sexual, and financial. And there's been some debate over the years about how common abuse is. So I just draw our attention to the most recent prevalence study. And since it's the most recent, I've put the citation on the screen. And that study looked at community dwelling adults and found that 7.5% of adults age 55 and plus experienced abuse in the past year. And this study is a really useful one because before actually starting on the research, they gathered experts together to discuss how to define abuse. And so it's a really nice document for getting a bit of a background. So with that kind of context, let's talk about the law on elder abuse. And interestingly, in Canada, elder abuse is not a legally defined term. There's no actual crime of elder abuse. There's no statute that I'm aware of that actually has a definition of elder abuse. And, some types of elder abuse are captured by the law and some not. For example, psychological abuse, there may not be a statute that applies to that. I will note that Canada's approach to say the criminal law of not including an actual specific crime of elder abuse is actually a policy choice, which I'll discuss a little bit later, but it is different than some other jurisdictions, such as the United States, where many states actually have a specific crime of elder abuse. Having said that, that doesn't mean that we don't take elder abuse seriously from a legal perspective. And it would take a very long time to cover all the different ways that the law might apply in situations of abuse. I'm going to more narrowly focus on laws where you can use it to respond, to prevent abuse, to end abuse, to deal with the consequences of abuse. And so, first of all, incidents of elder abuse may constitute a crime and criminal charges may be possible. There's no definition, there's no crime of elder abuse. So the actions that have occurred need to fit one of the other criminal code offenses, and I'm going to talk about that on the next slide. And additionally, most provinces also have laws that may apply and can be used to intervene or protect. And I will also give a brief introduction to that concept in a second. But let's first of all, so we have two sets of laws. We have the federal under federal jurisdiction is criminal law. So the criminal law applies across Canada. Plus, in each province, provinces can legislate in areas such as health or various regulatory areas. So there will be different statutes in different provinces, and those may apply to certain situations of abuse. We'll talk about that in a second. But first, let's talk about the criminal code. So elements of a particular incident of elder abuse may match the requirements of a criminal code offense. So some examples might be if there's physical abuse, that may match the crime of assault. If someone steals, commits theft by wrongly using a power of attorney, that may fall into the crime of theft of power of attorney or neglect. But the thing about criminal law is that in order for the criminal law to apply, the incident has to very specifically match the criteria or the elements of a particular offense. So I thought an example would be helpful. So Mrs. Smith criticizes her caregiver, Maggie. Maggie is really angry, so she slaps Mrs. Smith very hard across the face. This certainly would constitute elder abuse, but is this a crime? Well, let's look at the criminal code. A person commits an assault when, without the consent of another person, he applies force intentionally to that other person directly or indirectly. So in order for the Crown to make out this particular offense, to bring charges to be successful in court, the Crown must prove beyond a reasonable doubt that Maggie intended to apply force. It certainly seems, given this short scenario, that she intended to slap Mrs. Smith. She knew that there was no consent. Certainly, there's nothing in these 3 or 4 sentences that suggests that Mrs. Smith said, Maggie, it's okay, you can hit me. So she arguably knew that there was no consent, and she applied force. She slapped her. So I would say, just based on this particular information here, that would constitute this particular crime. So it's not the crime of elder abuse, it's the crime of assault. However, there is a couple of things that I should add to this. That first of all, the standard for proving things in criminal law is quite high. The Crown must prove it beyond a reasonable doubt. That doesn't mean there can't be any doubt, but the doubt can't be reasonable. It's a very high standard. It's a heavy burden of proof. And so, in order to make this out as a crime, the police would gather evidence, by interviewing Maggie and probably Mrs. Smith and certainly Mrs. Smith, and would gather other information to see if this crime had occurred and would decide whether to recommend charges. And the Crown would decide whether to proceed. There's policies that guide that. And then when it comes to court, that evidence would have to be presented so the court could be convinced that beyond a reasonable doubt that Maggie had assaulted Mrs. Smith. So that's the criminal law. So as I already mentioned, criminal law, before I go to the next slide, I should say that just in that description, and many of you may already be aware of how the criminal law works, I think it's self-evident some of the reasons why a case might not go forward. The police may believe that something occurred, but there's not enough evidence to prove it beyond a reasonable doubt. Someone might not want to testify. There could be all kinds of issues there. But moving on to provincial legislation has a very different purpose. The purpose of provincial legislation, to speak really broadly, is to regulate and ensure public safety. However, these provincial statutes can sometimes be used to intervene in situations of abuse or neglect, or where adult is going to be harmed. And the laws would be different in different provinces. So all provinces, for example, would have laws that regulate residential care. So if an older adult is living in a residential care, abuse or neglect occurs, there could be a complaint to a regulatory body and actions could be taken. There's a much broader range of laws. There are some provinces, and Ontario is not one of them, where there's a particular law that applies to vulnerable adults living in the community. Those laws don't usually refer to someone, specifically to someone who's older, but they may apply. So the province I'm originally from, British Columbia, has a law where the health authorities can intervene if someone's abused or neglected and unable to seek support and assistance on their own. And most of those cases involve older adults with dementia. So I should flag that sometimes complaints or interventions can occur just by putting in a complaint to the right body who has scope to intervene under statute. There are some situations where, say, a court order or something might be needed. And the thing about civil law, so provincial law that's not under federal jurisdiction, is that the standard of proof is lower. It's on a balance of probabilities. So it means that the matter occurred, it's more likely that it occurred than it did not. So should something need to be proven, the standard is much lower for provincial legislation. So let me now move on to the next section here. That's by way of background about the laws. But I should say I'm going to focus now primarily on Canada's criminal law response, although I certainly, just because provincial laws are different and because I've done some recent research on this particular topic, but so there's criticisms that could be made of provincial law as well, but I'm going to focus on criminal law at this point. So Canada's criminal law response to elder abuse has been criticized. Very few cases are charged, and which raises the question about what should be done to improve the situation. And there have been very few cases, very few research projects to show why there are very few cases where charges are brought. So there's not been much actual study, but experts have stated opinions on that, and I'll talk about that a bit more in the next slide. So the concerns about the criminal justice system were the subject of a recent parliamentary study. And this study wrapped up in 2021, and a number of different experts, scholars, people working in the elder abuse field gave submissions to this committee, and they wrote a report at the end of it. And the report has some recommendations about what to do to improve our criminal justice system and elder abuse. So some of the things that came up in there, I would suggest are, it was discussed in the submissions to that report, the fact that, experts said that there can be problems with training. They cited a lot of different issues. Other research has suggested that ageism can play a part in whether or not to bring charges. There can be concerns on the part of Crown and defense about the difficulty of proving the case, and that can be an impediment. Whether or not it will be difficult to prove the case, the perception that it will be can play a part. So if you think about it for a second, proving this beyond a reasonable doubt on the stand, somebody who is older might not be the best witness. There could be a disability, there could be cognitive issues. And so there could be a reluctance on the part of the Crown and the police to bring charges. However, that doesn't mean that we shouldn't address this problem and make the criminal justice system more accessible. I also should note that there can be reluctance on the part of the victim to testify. Many perpetrators actually are family members. And so older adults can be very reluctant to bring charges. And in some jurisdictions, they're now using restorative justice as an alternative approach. So try to work out a plan to keep the older adults safe without going to court, and to have some consequences to the perpetrator without actually going through the court process. So it's kind of a diversion. That's a bit of an aside, but I'm just saying there's been a long discussion of what some of the issues are, and many of these came up at this standing committee. I should note a couple of policy issues that came up. So, and different people who spoke there had different views on this. So I mentioned on an earlier slide that Canada has a different approach to most American states. So many American states actually have specific crimes of elder abuse. And of course, the question is, how are those defined in the statute? And I'm not aware of any research that shows how effective that is. It's a bit of a challenge because, of course, the wording is different in different states. But there was a debate at this particular, with all the submissions to this particular study, about whether Canada should actually adopt the American approach and actually have some crimes of elder abuse. And so essentially, there was a debate about this issue. The committee held four meetings to hear from witnesses, and received 12 briefs in addition to the witnesses. And, some of the groups that attended said the problems were with implementation, and others pointed to wording of the criminal code itself. And one of the issues with the wording was, we don't have an actual crime of elder abuse. Maybe this is a problem. That was very controversial. Different people making submissions had different views of that. And secondly, Canada, although we don't have a crime of elder abuse, we do have the capacity to increase the length of the sentence if the victim of the crime is actually of an advanced age. So, and many of the submissions to this committee spoke about this particular provision, and many said that it was a great innovation, that it worked well, it was a way of dealing harshly with crime, and others said that, well, it's not that effective because not that many cases go forward. So if no one's convicted, you can't increase their sentence. and that money should be instead directed into improving some of the supports and assistance for victims of crime. So to give just a little bit of, I'm going to jump ahead to that in a second to discuss that. But first, I thought it would be worth just mentioning what some of the recommendations were that came out of the parliamentary study. Whether or not we adopt the American approach to having crimes of elder abuse, which, by the way, I'm not particularly in favor of for a number of reasons that I won't go into in my presentation. But it may be that we need to have a better understanding or better definitions of what elder abuse is from a legal perspective. So the committee proposed spending some time doing research on that. Improved funding. I think this would be universally agreed that we need more training for justice system personnel, we need better funding, etc. So that would be recommendations 2 and 3. And there were more recommendations than these 5. I'm just highlighting the 5 that jumped out to me. There was this discussion of whether or not we should have a crime of elder abuse. So recommendation 5 said we should look at that issue more. And then the recommendations proposed examining the aggravating factors in sentencing. So that provision that I mentioned a moment ago. So I decided, okay, so we've had this standing committee research, and experts were divided on whether this particular provision is actually helping to address elder abuse. So why don't I investigate that? So I decided to do a study. And so this is a provision in this section of the criminal code, and it actually was added to the criminal code in 2013 under an act called the Protecting Canada's Seniors Act. However, it actually doesn't specify older age. This is the wording right here that I have up on the screen, that the judge can consider the age of the victim and their personal circumstances when deciding how long the sentence should be. And this section of the criminal code, section 718.2, actually has a number of different provisions, and it's essentially a list of factors that the court can consider in deciding whether to make the sentence less. That would be a mitigating factor, or to make it more, which would be an aggravating factor. And other aggravating factors include things like if the perpetrator was in a position of trust, for example, if it was a hate crime, etc. So there's a variety of other factors that can be considered in sentencing. So this is how aggravating factors work, and this is the provision. Now, when the Protecting Canada Seniors Act was introduced, it was introduced with great fanfare by the government. A government press release at the time quoted Minister Nicholson as saying, "Our government has promised to better protect elderly Canadians, and today we are one step closer to achieving that commitment. Senior Canadians have spent their lifetime building our families, our communities, and our country. We must ensure greater protection for them under the law." However, in contrast, some experts at the time projected that this new provision would accomplish very little because of the way that it was worded. So I'd like to draw your attention again to the fact that even though this is was introduced under the Protecting Canada's Seniors Act, it mentions age, but doesn't actually mention that that's advanced age. So this was criticized by experts. And also, as I already mentioned, there are other aggravating factors. And so an argument could be made that the courts already have the ability to increase the sentence in cases of elder abuse. For example, perpetrators are often in a position of trust. That was already an aggravating factor in the statute. So that's kind of the debate that occurred at the time. And that debate was then also reflected in the standing committee's research that I described earlier. So the parliamentary study, this debate was reflected in some of the comments made by people who made submissions, which had different views on this. So I decided I wondered which perspective was correct. And I decided that I would do a little study to see how this particular provision is being used. Okay, so there's the capability in the criminal code. Then if somebody has, if there's a case of elder abuse, there's a conviction, not as the crime of elder abuse, but say somebody neglects somebody who's older or assaults them or commits theft by power of attorney or one of these other crimes, there's the capability for the court to increase the sentence. That's seen from a policy perspective as being appropriate. Somebody arguably deserves a longer sentence if they're taking advantage of somebody who's, susceptible or more vulnerable because of their age or circumstance. But is this what's happening? So I decided to look at cases. So I looked on various search engines for legal cases. For any cases that mention this provision, 718.2A 3, that should have a 0.2 in it. I wanted to look not just at how many cases there were, but also what the court said, how they were using those cases. So I looked at how the court saw the purpose of the provision as being, how the courts are interpreting this particular provision. So we saw a few slides ago, or last slide, that this is how the provision's worded. How are the courts doing this? How are they considering the age and personal circumstances of victims if they're older? And what types of cases or circumstances this provision being applied to? Aha, so the findings. So I should say that I did a fairly extensive search. I actually had several students assisting me with this. One year I had one student do a thorough search with my assistance and supervision. I wanted to make sure that the findings were correct, so I subsequently had two other students searching. And what essentially was found is this has been law now for 10 years. But this provision is not used very often. We only found 40 cases where the victim was older. Now, I should note that sometimes courts will release judgments and they're oral judgments. There's no written judgment. So it's possible and probably likely that there are other cases where the court actually mentioned this provision or took age into consideration. Nonetheless, I think that 40 cases over 13 years is such an astoundingly small number that it speaks to that. So that's the first conclusion I would draw. Secondly, where this was used, there was a lack of clarity about its purpose by the court. Now, as you'll recall, I mentioned that experts suggested that this would not be effective because the provision wasn't worded clearly enough. And I would say that that argument could be made. I found that in some cases, the court was very clear. One case, the court mentioned this provision, said that it was specifically to address elder abuse and referred to the Protecting Canada Seniors Act. But there's other cases, for example, a case called R.N. Adamco, where the court said that the wording makes it completely unclear what the purpose of this particular provision is. So the courts didn't even always realize what this provision was for. And also, as the experts had concerns that this wouldn't really add anything because it was already possible for courts to consider to impose an aggravated sentence in cases of elder abuse, I'd say that was borne out with this research, that it was actually the word I would use, duplicative. So in cases where the court actually referenced this section and the age of the victim, the court often would refer to other aggravating factors, like I already mentioned, a position of trust can be an aggravating factor. So, oh, and I forgot to say something very interesting about this. This provision was so unclear, the purpose of this provision to the courts, that we only found 40 cases where it was used when the victim was older. However, there were quite a few cases where the court used it when the victim was younger, which certainly, by the wording of the statute, if we look at it again, the court just has to consider the victim's age. So the courts were using this to give aggravating sentences when the victim was younger, even though that wasn't the original purpose of the statute. So the second thing I found is that when this provision was cited, the court found that an aggravated sentence was appropriate for one of two reasons. First of all, the court said that they were imposing an aggravated sentence, like an increased sentence, a longer sentence, because of the impact of the crime on the victim, and also the vulnerability of the victim. And I think if you look at the wording, skipping back again, certainly this provision mentions the personal circumstance. So I think that that aligns right with the wording of the statute. It doesn't mention vulnerability, but there's no reason a court couldn't consider that. So let me briefly talk about what the court said about impact first. The majority of the cases where this provision was used, remembering I only found 40, the court discussed or mentioned the specific impact. Often the court referenced a victim impact statement. So as many of you know, if a case goes to court, the victim can make a statement that the court can consider in sentencing. And so the courts were specifically referencing victim impact statement. An example can be found in a case called R and Fontana, where the victim explained the impact in the following words: "My lifestyle has been dramatically and severely impacted. I can no longer enjoy wining and dining, no longer visiting art galleries, and no longer being able to attend and enjoy other artistic activities, not to mention not having the ability to afford and enjoy vacations in the golden years." So this was a case where the adult was financially abused. Other specific impacts mentioned in the cases include decline in health, loss of finances, and long-term impacts such as losing independence due to needing additional care and losing financial security. When the courts reference the term vulnerable, the court used that term in one of two ways. And I found this particularly interesting because there's a lot of literature on vulnerability and what that means. I'm going to just discuss that briefly on the next slide. But first of all, let's see what the courts said. So some courts ascribe vulnerability to a particular quality, which essentially is assuming that all adults with this particular quality or identity are vulnerable due to having that. And the two inherent qualities referenced most commonly were Alzheimer's or severe dementia, with the court assuming if that was present, that the adult was vulnerable. And secondly, if the adult had an older chronological age. And just to kind of flag why I found this interesting is I was concerned about the comments of a couple courts where there seemed to be an assumption that if an older adult had dementia, that in and itself was enough to make the adult vulnerable. An adult could be at a very early stage of dementia, could have lots of supports around them. Not to argue or debate that particular point, but my concern was just the wording of how the court described having Alzheimer's and drawing a comparison to being children, etc. So I was a little concerned about that wording and some kind of ageist implications. The court also, some cases, they referred to circumstances that caused the victim to be vulnerable. And I would say that, so some of these include factors such as lack of strength due to being older, age differential, poor health and mobility, issues preventing the older adult from fighting back. And I would say that if the purpose of this particular provision is to have a harsher punishment for criminals who are taking advantage of a situation, certainly it seems to me very meritorious to increase the sentence if somebody, say, robs someone who's older because they know that person doesn't have as much strength to fight back or that type of thing. I also would argue myself that the second line of cases, the one that associate vulnerability with circumstances and factors that in many ways that those fit very well with best practices and emerging legal theory, that many scholars are now talking about how vulnerability is both a combination. There could be some internal inherent qualities that make a person vulnerable, but also vulnerability can be exacerbated by circumstances. And sort of this aligns with research that identifies risk factors such as social isolation, living with a dependent adult child with mental health or substance abuse issues, economic factors. And then, obviously some studies also show that having dementia there's an increased prevalence of elder abuse. Caregiver stress or burnout has been identified as a factor, but not as predominant of a factor as some early scholars thought. So there are a number, I'd say, of policy implications from the study, sort of stepping aside from those comments about vulnerability and how I would interpret the study, just looking at the aspect of how this provision is being used, how often it's being used, and whether it's meeting the originally policy objectives. I would argue that it's not meeting the original objectives. It's not being used very often. And many of the cases where the judges actually reference this provision, they didn't understand the purpose of it. And in many ways, this fits with what some of the experts said prior to when this provision was being introduced to the Protecting Canada's Seniors Act. It's ambiguous. It doesn't mention that the victim must be older. And there's the practical problem is that there's very few convictions for elder abuse cases. And I did another research project, very preliminary, also using with the assistance of research assistants, where we did a comprehensive search for cases that could be tied to incidences of elder abuse, and found not a great amount of cases there. So in addressing some of the immediate concerns, I would suggest revising. I think having an aggravated sentence in cases of elder abuse makes sense, but it probably needs to be reworded to reference older age, and there probably needs to be some training about what that is. It's worth conducting other research to see where the criminal code could be tweaked to be improved. And what is known for sure, though, more research is needed there, but what is known for sure is that additional resources and supports are needed for victims, that additional training is needed for justice system personnel at all levels. This will help more charges to go forward. As I already pointed out several times, you can't really have an aggravated sentence if nobody has been charged. So addressing that by making it easier to bring charges and supports for victims. Not all victims want to participate in the criminal justice system, so having other measures and ways to assist older adults and to intervene. There have been some great projects using restorative justice or other approaches. And I could talk about that at great length, but there needs to be other alternatives to the criminal justice system as well. And so I think that's all the comments that I have for the moment. I could make more comments, but I think I'd like to stop now and leave plenty of time for questions. And if there are not enough questions, then I'll make more comments, but I'll turn it over and see who would like to ask a question at this point. And maybe I will stop sharing so that I can have a better look at things here.
Perfect. Thank you, Dr. Braun. That was very, I don't know if enlightening is the word, but yeah, it was surprising. Anyway, yeah, I didn't realize there were there was this sort of lack of specific laws in place. Um, but
Well, I would say that yeah, I don't know, as I've already said, that the solution would be to have a specific law of elder abuse. Personally, and speaking as somebody who worked in the field, I think a lot of the reasons charges don't go forward actually has to do with what happens at the front end. Not enough support for victim, not enough resources, not enough training, not enough alternatives. If an older adult is, say, the person, statistics show that the perpetrator is often a family member, they don't want to bring charges. That might be their supporter or their caregiver. So having some alternative where they can live and get support. So personally, I would recommend that we put our attention there. However, I think it's really worth walking through and considering what the criminal justice system can and can't do, especially with this particular provision I've talked about, since it's been lauded as an example of how Canada's really doing something and accomplishing something through this provision. I thought it was worth looking at and seeing, well, is that true? What's happening? How effective is it?
are there any lessons that you think that Canada could learn from, say, the United States? You had mentioned that they do have states that have specific laws in
Yeah.
place. Do you think there's anything
So
that Canada could do better in that regard?
So I wouldn't look there. I might look at the states, but for a different reason. They actually have put more money in, or they have some programs that really enhance or have put more efforts and resources into their response, both civil and statewide responses. So there's more training, more specialized programs. I mentioned that I did some research looking at response to elder abuse, didn't find many cases. As a subset of that, I actually looked to see what Canada was doing specifically to respond where the victim had dementia. And I actually found very few programs in like the courthouses, that type of thing. But if I contrasted that to the United States, many jurisdictions, they actually have special training for police officers and those types of programs. I mean, we could critique whether that works well or not, or how effective that's being, but it's a real start. And what I'd say is it's a product, I'd say, of two things. First of all, because the United States has an Older Americans Act, that's led to some funding specifically in this area. And the United States also has adult protection legislation, which we could talk about another day. But a side result of that is it's ended up having resources put into things like training and supports and that kind of thing. So I think it's at that level that we could maybe learn something. I went to a really interesting workshop that was provided actually by the Department of Justice, and it had somebody who was very senior in the Department of Justice on the first day introducing all the speakers, and they had 3 days of different speakers from the criminal and civil justice system talking about response to elder abuse, and we just don't have that much happening. So that's where I would adopt something from the states at the implementation level rather than the actual changing, because we can change how something's phrased, the wording, the definition, but if we don't have the resources to support victims or to do training, it's not going to actually address the problem. So that's what I would actually say.
Thank you. If anybody has a question, like I had said earlier, please, you can raise your hand and take yourself off mute if you feel comfortable. If not, please put it in the chat. I noticed that we do have a lot of frontline workers and healthcare providers and social care providers in the meeting right now. Do you have any advice for that demographic when it comes to maybe advocating or being more supportive?
I could say lots of things, but let me just give a second. Let me open up the floor to that question. And is there anyone who's in the healthcare field who would like to quickly flip in the chat, even if it's not something that I haven't talked about? What's a question that you find to be particularly perplexing in responding to this issue in your work? And that way I can tailor my remarks to the things that are particularly important in Ontario rather than talking kind of generally. If not, I'll talk, I'll provide my own tips, but I want to give a chance if anyone wants to volunteer to just maybe give a couple suggestions of where you'd like to focus my remarks.
people a moment to type it in if they need to, or oh,
Oh, I see
Kevin.
it.
I had a feeling you were going to talk, Kevin. I don't know.
Hi, Kevin.
Hi, Joan. Thank you so much for everything that you've brought to us today. The thing that's most stunning for me is that there is no consensus or coordinated effort in this regard. It's staggering that that's the case. I spent a dozen years as a client care coordinator with the company that provided in-home care. Retired a couple of years ago. I'm studying to be a death doula. I've often found myself in a situation where I've had conversations with families and staff around this issue. And I think a lot of people just assume that there is legislation, that there are things that a peace officer can do, that there are things that a court could do to help people in this regard. And I was one of those people. I really thought that we had more on the ball in Canada. We had a greater, a deeper level of respect for the seniors in our community and the elders in our community, that we had a mechanism or a remedy for this kind of thing. And I really appreciate the fact that you've brought it forward.
Yeah.
I know that in our community, the Métis community and First Nations, most definitely, there is a respect, a reverence for the elders, for our ancestors. And it's stunning that it's not part of our system. So thank you for that. I appreciate it.
Yeah, and I could now respond actually very specifically to the example that you've given, Kevin. And this would help to also explain why I think that front end work would help. So some jurisdictions, and there's a few in Ontario and a few in BC, but not enough. There's actually like specialized units that deal with elder abuse. But I'll speak more specifically about one of those units in BC, just because I know the social worker that works there. So in those particular initiatives, they'll have, for example, a social worker who works along with an officer to bring charges in cases of elder abuse. And I know the social worker who works in the Vancouver unit and for many years, and she commented that many times she would spend like 10 or 20 hours with the victim and working on the case before they would actually bring it to the police officer. Because if you think about what I said about how the crime is, say, not a crime of elder abuse, it might be a crime of assault. A victim who's traumatized may not even actually be able to explain what happened to them in a way that initially it may not sound like it matches a particular crime, just to give an example. So having a social worker involved, they can hear the story, they can help the adult process whether they want to bring forward charges. When it gets to the point where it's kind of in a frame that will make fit better with the legal system, then they can go as an advocate instead and help the person tell their story to the police officer and to do that kind of thing. So I actually think that we could take the laws that exist, which is why I don't necessarily think we need a crime of elder abuse, but something needs to happen at the front end to do that part of helping victims tell their story in a way that officers will understand, that ensures that they have protection from the perpetrator while the thing is going forward, and just so many issues. And that's very intensive. It's not ideally done by a police officer. And so having programs and things in place that enable that to happen, I think is a very effective approach. I think it's probably just money, with the reason that doesn't, isn't in every jurisdiction, but I think that's really helpful. And it's very upsetting, I think, to people if you know somebody who's a victim and they aren't getting help and you can't do anything. It's a really troubling situation. So, yeah.
I really appreciate what you said, especially with the social worker investing that time.
Yes.
When you're working with elderly people, it often takes a couple of hours to bring clarity to one point, never mind
Yes.
a situation that's kind of confusing for them. We had a situation where one of our clients had a fall in their home,
Yes.
and our staff member had turned her back. And so the next thing that happens is you get a call from the daughter saying, "Why wasn't she watching my mother?" Well, maybe she was watching the whatever. So there needs to be an investigation, needs to be a conversation. And so it's when there's responsibility and accountability where you're looking at moments,
Yes.
sometimes it takes an hour to get to the bottom of it or more. And you're absolutely right. It could be a social worker with that set of skills. It could be an RPN. It could be someone that knows that person, a PSW, who can interpret,
Yes. That's
because
exactly.
oftentimes it's interpret what they're saying to you, because we all use words differently. We use language differently. And you have to get the people to know them involved and the people that work with them. Otherwise, a peace officer knows how to ask specific questions, but they're not great with nuance. They're not. Does that make sense?
It makes perfect sense, Kevin. And the reason is it's very true what you just said about the older adult may need some help, like, explaining what's happened. I think that's true of anyone who is dealing with the legal system. Is often very different what a person's nuanced experience and something that fits into the legal, but it's also particularly true of victims and particularly true of older adults. And secondly, even if people in the justice system are concerned, they're really trained to look for what's legally relevant. And if the victim uses the wrong words, describes this in a way that sounds like it's not legally relevant, it might not be heard, which is why having somebody to do that translation is so essential.
Mm-hmm.
I thought I
Yeah,
saw
I
another
think,
hand. Did I?
yeah. I think there is a question in the chat. It says, it's from Alicia. She says, "Hi, Professor Braun. Are you able to speak more about cultural differences and how they impact this area or data?"
Oh, that's a good question. There has, I think cultural differences is an area where more research could be done, particularly when it comes to uh, how this interplays with the legal system. I mean, certainly there's going to be communication differences because of culture, but there also could be different values. So if, for example, somebody was a victim, they're from a culture where that really prioritizes kind of family cohesion and so on, they're not going to want to, that's going to be an added factor in not wanting to bring charges because they're not going to want to bring shame on the family, etc. And this is why I believe that it's so essential that there be other supports and other approaches. Some of those could address it. And actually, I just thought of a project that might interest or is relevant on this point. Somebody I know did this project, and they got funding to deal with elder abuse issues from people from different cultures. So they ran this through a neighborhood house, and they called their project Finding a Home, because they had people from different cultures who were part of the project team, and they said that it wasn't comfortable to use the term elder abuse. So the whole project was about how to make your home safe and how to make your home better. So they actually were able to do education and even to discuss legal issues, but it was all framed around this different term about your home and how do you create a different home. And so it was very culturally relevant because of who was involved and because of the great work that the person running that project did.
That's very interesting how just, tweaking the language a little bit makes it a little bit less scary
Yes,
or,
yes,
yeah.
yes,
Yes, thank you. I just thought of something too of like a client, a past client of mine. I don't think she didn't realize she was being abused financially because it was her son, right?
yeah.
And she always supported her son. And so it took a lot of convincing on, well, basically it took her having no money left to convince her that, yeah, she was being financially abused.
That's very tricky. And I did a research project in BC actually, which was with social workers working for the health authorities, the hospitals, because there's a statute there where they're the designated responders to abuse. And they talked a lot about this particular issue with sorting out whether somebody actually had been financially abused, because someone might be a victim and think they're not. They think that they gave the money willingly, but then again, because of ageism, it might be assumed that somebody is a victim when they genuinely wanted to give the money. And so it can be really that issue can be really quite complicated. And plus denial. Another study that I know that was done a long time ago, the person doing this study actually came up with descriptions of elder abuse that matched a financial crime. So the person was a lawyer, and actually then interviewed older adults about managing money and asked them if they knew anyone who had experienced anything like this. And it was only through discussing it with the participants that she discovered that a high percentage of them actually themselves had experienced this. The statistic she came up with, I think, was that 8% of participants in her study had experienced financial abuse, losing money amounts of more than $20,000. So it wasn't small financial abuse. So
I believe it. And, I think of another client. We had found out that he had paid, I think, his daughter's taxes, which were it was like $5,000. So it was not a small amount of money. And his other daughter found out about it and she was upset about it. And um, she was POA. And so actually we told her that this had happened. We just said, we want to give you a heads up. He had transferred this much money to your sister. And so she was very upset. And so then he was upset with us for telling her. And so it was this whole thing. And he said, it's my money, but it's my choice. But he also has dementia. It was just more on the moderate side or mild side. But again, it was one of those issues, at what point is this
yes,
maybe coercion or is this manipulation? It just felt like we needed to say something. I don't actually know what happened and what came of it. I don't think anything did, to be honest with you, but it was one of those things where we were, just on alert, like if this happens again and again, then we really should probably step in.
right. Yeah, and I'm seeing we're getting near the end, and I wanted to add a couple tips in response actually to your question. And I'll see that question as well. But let me first just say, as far as tips, I think what I would add is that the best thing to do is to empower yourself. I mean, recognize that the issues aren't simple as we're talking about. So, and I realize that that's frustrating. At the same time, though, find out who the best contacts are. So here in Thunder Bay, for example, there's a police officer that specifically deals with elder abuse. So, so that's a very good resource. Find out what resources are in the community and find out a little. So who are your allies? Who can help to advocate for the client? And also what specifically is the law in your jurisdiction? What's available? What's there? So part of it is by empowering yourself. I know that the law can be quite intimidating in the legal system. So that's just part of what it is. And I find that the best way to deal with it more effectively or to be more comfortable is to grow in understanding as much as you can about what the situation really is. Oh yes, cognitive impairment and consent. So this is a difficult, very difficult issue, especially for healthcare workers. And we may not have enough time. I'm happy to talk to anyone who wants to email me about this specific issue afterwards, because it's more complicated than I can do in 3 minutes. But I guess what I'd say is that essentially, legally, someone has to give consent to treatment or any of that type of thing. And there's statutes. There, even a situation where somebody may not be capable of giving consent, the person that's still their legal right, unless there's sort of a statute that displaces that. So in the healthcare field, if, say, a medical doctor or someone feels that the person is not able to give consent, there's a statute that actually can give the doctor an authority on a temporary basis to ask a family member as a substitute decision maker or to make the decision themselves in an emergency. That's sort of short term. But generally speaking, apart from the things that fall specifically there, that the law really is that a person is presumed to be capable of giving consent, and there needs to be some kind of determination that they're not by someone who has authority. So in that particular case, the doctor would have authority if it meets the criteria in that statute because it's an emergency or something needs to happen. And another way that someone might be able to give consent because they're a legal decision maker for the person, and that's pursuant to a document that the adult made out previously, where a court can determine that somebody who's a substitute decision maker can make a decision. So essentially, at law, a person has the right to make the decision themselves. They're presumed to be capable, but there's legal processes where it can be determined that their cognitive impairment is to the degree that they cannot make the decision, and then somebody who is legally appointed to be a substitute decision maker makes a decision for them. And the example I just gave of a doctor, that's a temporary substitute decision maker. And although it's determining whether the person is capable or not, it really often goes around two questions. Does the person understand the context of the decision? And does the person understand the consequences of the decision? So the reason it's a complicated area is it depends what the decision is. The process for appointing a substitute decision maker could vary, and specifically what a court would be looking at to determine that the person's not capable might be slightly different depending on what the decision is. But in a nutshell and simply speaking, it tends to be those two questions. Is the person able to give consent? Do they understand the consequence? So for giving consent, say to a treatment or something, would they understand what they're being asked to consent to, and are they able of understanding the consequences of making the decision? So in a brief nutshell, but when you get my slides, you're welcome to email me.
Yes, I will include that in the post webinar email. And it should also be noted, just as a thing, that capacity fluctuates as well.
Yes,
right? Capacity fluctuates depending on the time of day. It also fluctuates. Yeah.